This presentation is based on a paper I gave at the International Conference on Reason and Religion at Minhaj University in Lahore, Pakistan in 2019. It was later published in the South Asian Journal of Religion and Philosophy by Minhaj University in 2020. The title of that talk, that paper, was Islamic Law, Western Law, and Religious Values in the Global Age. I'll just read a portion of the introduction or abstract from that talk. Each of the three historic legal traditions, Anglophone, civilian, and Islamic, represents a different premise of underlying values, especially those values expressed in supernatural or religious terms. Examining how each of these three traditions gives expression to or is validated by a larger context of religious belief is useful in understanding the architecture of global law being constructed in the 21st century. For example, Islamic law, or Sharia, with its universal values, claims a prophetic origin. It makes no clear distinction between the realm of law by which practical affairs of the world are conducted and the divine obligations by which all men and women are admonished to live. However, ultimately, its way of life rests on a high level of cultivation and learning among the Muslim population generally. By contrast, the continental or civil law resembles Islamic practice in that historically it was also based on universal Christian values that were thought to provide equitable and humane standards applicable to all persons. Even though in its modern form the purely theological language has been displaced with secular constructions of philosophy and ideology, that law still reflects a moral standard of religious origin. Moreover, like Islam, it has also recognized a high level of personal cultivation as the true foundation for public order. In the matter of religious values, Anglophone or common law is fundamentally different from the other two legal methods in several important ways. First, originating as a fraternal trade in the commerce of litigation, it operated apart from religious norms and was insulated from public understanding. Its legitimacy rested on a strict division of knowledge between public and practitioner regarding how the law worked. Rather than relying on cultivation and learning among the public, its strength rested on unity and discipline within a closed fellowship. In fact, the legal result it produced claimed no necessary relationship to religious norms or conventional standards of morality among the public. For this reason, it has often been referred to as a value-free method of law. However, at the same time, its legitimacy among the public has historically relied on an atmosphere of religiosity that conferred an aura of sanctity on its institutions and procedures. By this means, it sought to instill in the public a habit of compliance based not on understanding, but on faith. These differences between the three great legal traditions take on an added importance as the Western project of globalization becomes increasingly anglicized. The principles and methods of civil law are being subsumed in a process of convergence. At the same time, Islamic practice is being reconstructed in ways to fit it within the definitions of a tolerated religion. The question arises as to whether a global rule of law will be informed by any type of religious or sacred tenet, and if so, what will it be?